Hello, I'm Sheryl McCarthy of the City University of New York. Welcome to One to One. In the 1960s, Congress passed a bill that would permanently change the workplace for women, although at the time, what its impact would be was far from clear. Women's inclusion in Title VII of the Civil Rights Act of 1964 was an afterthought, but the effects were far-reaching. Title VII made sex discrimination in the workplace illegal. But how did one prove sex discrimination? That was a challenge facing the brave women who insisted that their voices be heard, all the way to the Supreme Court. Gillian Thomas, writer and lawyer with the ACLU's Women's Rights Project, tells the stories of some of these women in her new book, Because of Sex: One Law, 10 Cases, and 50 Years That Changed America's Lives at Work. It's just been published by St. Martin's Press. Welcome.
Thanks for having me.
Your book focuses on 10 Supreme Court decisions that were brought under Title VII. Why these 10 cases?
I felt that the 10 cases that I ended up including covered three key themes that I felt typified women's development in the workplace and their advancements in the workplace. One theme was motherhood, pregnancy and motherhood, which obviously has always been a barrier to women being in the workplace and frankly continues to be, albeit with new problems. The second issue was stereotypes about the kinds of work that women wanted to do or were able to do. And related to that, stereotypes about what they should look like, how they should act, what was being a woman on the job. And the third theme was sexual harassment, which at the time that Title VII was enacted didn't have a name. It was just the way things were, how men and women interacted in the workplace, and it was expected. And the shifting of that from just the way things are to an acknowledgement of actual discriminatory work conditions.
And sexual harassment as a civil rights issue, really.
Precisely. So those were sort of the three macro areas I felt really represented women's advancement in the workplace, and I picked the cases accordingly.
I mentioned that women's inclusion in Title VII was an afterthought, almost a joke, really.
Well, we all know the 1964 Civil Rights Act as a monumental achievement for civil rights in the lives of African Americans, and the Civil Rights Act addressed all areas of American life. Title VII was the employment section, and a couple days before final floor debate on the bill, Representative Howard Smith of Virginia, a Republican and an adamant opponent of all of the Civil Rights Act, proposed the addition of sex. It's long been the acquired or the accepted wisdom that he did it as a joke to sink the bill, that he felt that however palatable it had become for African Americans to be recognized as equal citizens, at least under the law, no one would agree that women should be included too, and it would sink the bill. More recent historians who have delved into the history would say that it's more, his motives are questionable and he himself perpetuated the joke myth, but that it was probably more likely out of a genuine desire to advance women's issues, at least white women's issues. He was a big supporter of the Equal Rights Amendment and the National Women's Party, which was the central advocate for the Equal Rights Amendment, pressured him, look, if this bill passes, black women, by virtue of their race, are going to have more rights than white women on the job.
And we can't have that.
No, we can't.
The first case, these cases go from 1971 to, I think, 96?
Actually, more recent, 2015, actually, the most recent one. Yeah.
That's right. So going back to the first one in 1971, how would you describe the working conditions of women in 1971?
It was very much still the world of 1964 when the law was passed. It was a man's world, a world of man's work and woman's work. Women were clustered, to some extent as they still are today, in lower paid, supportive roles, secretary, nurse, teacher. Only recently, by the time the first case was heard, had want ads stopped being separated by gender. Men had access access to unionized jobs that involved the kind of heavy lifting and long hours that women had long been presumed not to be able to do.
And better pay and better benefits.
Absolutely, and opportunities for advancement and becoming supervisors and so forth, that's right. So it was a very divided world, and a world also in which people were still grappling with what equality on the job even meant. The EEOC, the Equal Employment Opportunity Commission, the agency charged with enforcing Title VII, was only just finding its sea legs with respect to what it was supposed to be doing to enforce the law. And the first case in the book, Phillips v. Martin Marietta, was not only the first gender case to be heard by the Supreme Court, but the first Title VII case to be heard by the Supreme Court at all. It was that new.
So you said there are three, basically the cases fall into three categories, so let's talk about them. The first one had to do with pregnancy and motherhood.
And I think it's not at all surprising that the very first case that the court heard was about a mother trying to work. And the case was Ida Phillips, who tried to get an assembly line job with Martin Marietta, the defense contractor. And she was turned away because she had a daughter who was in preschool. She had 6 other children who weren't in preschool, but she had a preschool-age child. And the company adopted a rule that only that women with small children could not be hired. Men with preschool-age children could be hired, but women with preschool-age children
couldn't. And was the rationale that women are going to, you know, the kid's going to get a cold and they're going to have to take time off to take care of them? Was that it?
It's that, and take
or
that.
Women ought to be staying at home. What do you think was behind it?
The rationale that the company articulated during the case was more that women were unreliable, so that they had higher rates of absenteeism, higher rates of lateness, needing to take phone calls during their shifts, and so forth. Ida Phillips had plenty of childcare and backup childcare, so she was never even given a chance to show that she could do the job. And the notion was that the company was acting on a stereotype. Unquestionably, there are some parents for whom childcare interferes with their ability to do the job. But what the court was faced with was this blanket stereotype being used as a blanket rule, the assumption every mother is going to be like this, so we're not going to hire them at all. And what Ida Phillips' lawyer, and then later the NAACP Legal Defense Fund lawyer who represented her before the Supreme Court said was everyone is to be considered as an individual. If someone is late and someone has absenteeism issues, by all means fire them, but let them get on the job.
So how did when it got up to the Supreme Court, and these cases tend to take a lot of time.
Yes.
There are a number of decisions before it gets to the Supreme Court.
Yes.
What did the Supreme Court say?
The Supreme Court did find that this was a violation of Title VII, found it unanimously that it was a violation of Title VII, that a rule that just applied to women and didn't apply to men violated Title VII. What the company had argued, aside from its stated reason for the rule, was, listen, actually our workforce is 70% women. We don't discriminate against women. It's just mothers of small children we don't want working here. And so that was really the key issue that ended up before the court. It was about motherhood in the most immediate sense, but it was more about, can you exclude subgroups of women if still overall women are employed in the workforce? And so that was a big win beyond the motherhood context. I'll just note very quickly one thing that was very interesting about the case. I mentioned that the NAACP Legal Defense Fund got involved. Ida Phillips was white, but when the case came up to the court, the NAACP folks realized, first of all, most working women were women of color, so it was their constituency. But more importantly, that Title VII could be chipped away if it were and made meaningless if employers were allowed to take a protected class like race or gender and then apply plus factors like motherhood in order to exempt it from the rubric of race discrimination or sex discrimination. And
employers used to claim, we're not discriminating against women, we're discriminating against pregnant people, or we're discriminating against people, well, particularly with pregnancy.
Right.
And somebody came and said, well, the only pregnant people who can get pregnant are women, so if you're discriminating against pregnant people, you're discriminating against women.
It's per se going to be women, of
Right.
course. That was that's one of the really interesting chapters in our history and the history of Title VII, of the legislative and judicial bodies working very closely together, because there was a Supreme Court case that's not in the book from 1976 where the court found that General Electric's policy of giving disability pay for people who were out for a variety of medical conditions, but excluding pregnancy, wasn't sex discrimination. It was, as you said, just excluding pregnant persons.
Right.
And non-pregnant persons of both sexes were treated equally. So Congress reacted very swiftly by passing the Pregnancy Discrimination Act, which amended Title VII in 1978, amended Title VII to make it explicit that pregnancy discrimination or discrimination based on any of pregnancy's characteristics and treating pregnant women less well than others similar in their ability or inability to work was sex discrimination.
Now, a lot of the early restrictions on the kind of work that women could do, the kind of jobs that they could have, was framed in terms of its being protective of them. And that was the case with another one of the pregnancy cases that you write about in the book.
Yes. Well, when Title VII was enacted, there was a whole panoply of laws in place in states around the country called protective laws, which have a very interesting history. And actually, many women's activists had been the ones behind them because there was no labor legislation at the time. And these protective laws were seen as the only way of protecting women who were so disempowered in the workplace from being abused and exploited. Those were nullified by Title VII, but then in the mid-'80s, there was a movement afoot among employers to enact fetal protection policies, so-called because they excluded fertile women from any particular job in an employer's workplace that might put a developing fetus at risk. So the case in the book is Johnson Controls, the battery manufacturer, imposed in 1982 a blanket restriction on any woman who couldn't prove she was infertile. So it was not just that who could prove that she was taking birth control or otherwise was engaging in family planning, but unless she could prove that she was infertile, she was barred from any job that involved working with lead. And as you noted in your earlier comment, those were, of course, the best paying jobs. The other jobs in the plants were more janitorial work.
You actually had women who were getting sterilized so they keep their jobs.
That's right. That's right. And so the women's union, the United Auto Workers, started hearing about this policy, challenged the policy in court, and noted that this was a real throwback to these protective laws that were precisely the kind of thing that Title VII was meant to outlaw.
And as I recall, and the court said, you can't do this.
That's right.
Okay.
That's right. The court said you can't have one rule for women and one rule for men. As benevolent as Johnson Controls claimed it was, and of course you can question its benevolence, it might have just been worried about cost. Making jobs more safe is costly, but you can't say that women can't decide what kind of risks to undergo and men can. It also helped the women's case that the science showed that lead was as harmful or even more harmful to men's reproductive systems, and yet it was the women who were being kept out of the jobs.
It's interesting, if you go way back, I understand one of the early justifications of barring women from going to law school was that if they had to carry those heavy law books, it would, damage their reproductive abilities, and you didn't want to have that.
Well, I don't know if any of the people who made those policies have ever carried a toddler, but
right.
There's some heavy weights involved there too.
We're going to take a short break, then we'll be back with Gillian Thomas, author of Because of Sex, after this message. Welcome back to One to One. I'm Sheryl McCarthy of the City University of New York, and I'm talking with the lawyer and writer Gillian Thomas, author of Because of Sex, One Law, 10 Cases, and 50 Years That Changed America's Lives at Work. It's just been published by St. Martin's Press. So let's look at another area of the cases that you focused on involving sexual stereotyping.
Well, as we've been discussing, stereotypes about what women should do, what they should, kinds of jobs they should be interested in, were a constant throughout women's working lives. The case of Ann Hopkins versus Price Waterhouse really crystallized this and was one of the most important cases in the book. Ann Hopkins in the 80s was put up for partner at Price Waterhouse, the accounting firm. She was one of 88 candidates and the only woman. She had the biggest book of business of anyone who was put up. And she was held over to the next year. She wasn't granted partnership. And when she asked why, she heard that the partners reviewing her had said that she needed a course at charm school, that she was macho and overcompensated for being a woman. And then she went to her mentor at the firm and said, "What's your advice? How can I stop being myself and just make partner based on this advice?" And his advice was, you need to walk more femininely, talk more femininely, style your hair, wear makeup, and wear jewelry. So she got an attorney, and he enlisted a social psychologist who was able to prove to the court, the lower court and subsequently the Supreme Court, that reliance on sex stereotypes is a very common, even unconscious bias that people have. But the court held in a landmark ruling that relying on a stereotype that a woman is the wrong kind of woman is just as bad as saying we're not going to promote women at all.
You know, and some of these things that were happening, some of these practices that were found to be amount to illegal sex discrimination, probably even at the time, a lot of women bought into them as well. Would have said to her, you know what, let's go to the hairdresser, let's change your makeup, let's fix your dress, tone it down a little bit.
They do it now.
Yeah.
I mean, look at Hillary Clinton.
Right.
Women are just as harsh on her and her pantsuits and her hair
Right.
and her laugh as men are.
Right. Sexual harassment was something that has probably always been there, but was only starting to emerge as a civil rights issue in the 70s. And there was this horrible, horrible case that you write about in the book.
So you're right. The term sexual harassment only came into existence in 1975 and quickly gained currency as being an accurate description of what was going on. The case, there are two sexual harassment cases in the book, and the first one, Meritor Savings Bank v. Vinson, was decided in 1986, but it began, as you noted, these cases are so long, in the late 1970s. A young bank teller in Washington, D.C., 19 years old when she started working there, Michelle Vinson, was harassed for 3.5 years by her supervisor, and the harassment was really brutal, and in fact, much of it was criminal.
And he forced her to have sex with him.
That's right.
Under the threat of getting fired.
That's right. And under threat, she said, of physical harm and even being killed. And of course, that prompted a lot of speculation at the time. How could she have stayed? She must be making this up, and so forth. That's a whole different topic, the psychology of what happens to someone who's in the middle of sexual harassment. But the issue that was in the case was, prior to that time, the cases that women had been able to win, and there were not many, but the cases women had been able to win on sexual harassment involved, the typical scenario was a supervisor comes on to a woman, she rejects the advances, he fires her. So there was, or denies her a promotion.
There was an economic loss.
You got it. There was a tangible harm that could be quantified, literally. And Michelle Vinson, for all of the horrible emotional trauma and physical trauma she sustained, didn't suffer that way at work. She actually got promotions and was an assistant manager by the time she finally complained or got a lawyer. And so the question was, well, this environment that was just so poisoned by sexuality, was that illegal? And it was an utter seismic shift in our culture and in the law when the court said yes.
And so you had the labeling of this kind of environment, the hostile environment became the requirement. If somebody has, by their sexual harassment, if you has created a hostile environment for you that a reasonable person would not want to tolerate, then that's illegal under Title VII.
Right. In the Vinson case, the paramount finding was this initial standard of a hostile work environment is created when the conduct is severe or pervasive enough to create an abusive working environment. The next case in the book that addressed sexual harassment involved harassment that was far less on the spectrum, far less severe. It wasn't physical, for instance. It was all verbal. It was all of the kind we think of as typical sexual harassment, the leering, the dropping things on the ground to watch women bend over and pick them up and so forth. And you had another woman, Teresa Harris, working in Nashville, Tennessee, who managed to stay on the job and excel. She was a top woman manager at Forklift Systems. And so the question became in that case, well, how bad does it have to be? Obviously, what Michelle Vinson went through was an abusive working environment.
So the court handed down a less onerous standard.
It was the reasonable person that you mentioned, which is admittedly slightly mushy, but the idea was that if a reasonable person would find this environment abusive, then that's where the line is crossed.
Now, Ann Hopkins, the woman at Price Waterhouse who, after many years of litigation, won her partnership and continued to work at Price Waterhouse, was the only plaintiff who seemed to have been made whole by the Supreme Court decision. Most of the cases involved working class women, often single mothers who were struggling to support their families and were trying to better themselves. Their cases ground out on for years. They suffered enormous hardships, in a lot of cases. And then their financial settlements were small. They had moved on to different jobs, often by the time that the case got to the Supreme Court. So I wonder if, and a lot of these, black women, poor women, of course, Ann Hopkins was an educated, upper middle class white woman, and I wonder if the decisions had anything to do with that.
It's hard to know. I mean, the single mothers you talk about who had very little to show for at the end, or if not all of them were single, but run the gamut. And Ida Phillips, who in the very first case in the book, she was white. Peggy Young at the end of the book, she was white, but both worked in more kind of as we would call them, blue collar or working class jobs. Sheila White was a forklift operator. Lillian Garland was a bank receptionist, and Michelle Vinson was a bank assistant manager. And then we have the women of Johnson Controls, who were of all races, and the women of the Los Angeles City of Water and Power, who were of all races. So and unionized. I think the role of unions in these cases is always really fascinating. So it's hard to know. Is it because Ann Hopkins was white that her case progressed, or was Ann Hopkins in the position she was in because she was white? I mean, was she in a position to become a partner in the first place because
just better
she was
situated
white?
In the first place?
Yes, I think that's right.
Did they, despite the fact that they got not much out of these lawsuits, did they feel it was worth it?
201. I mean, some of them I couldn't meet. Ida Phillips had passed away, and I couldn't speak to the women who were in the union cases. And Michelle Vinson was the only person who refused to speak with me, which I attribute to how painful and horrible her case was. Everyone else I spoke to, and the attorneys, said unquestionably that they would do it all over again. As Lillian Garland said in one of the pregnancy discrimination cases in the book, it was 5 years of hell, and I would do it all over again. And
because they were doing something that needed to be done just on their behalf and on behalf of other women, on principle and because of the practical impact on other women, I would think.
Yeah, it was really both, and from the start for most of them. A couple of them, I think, sort of came to understand the wider importance of their case. When they began it, it was just
But most is like, this isn't right.
Yeah.
This is wrong.
That's right.
Most people don't even know these women's names. And the one plaintiff that most people may have heard of was Lily Ledbetter, who lost her case.
Yeah.
And this was a case, a lawsuit against Union Carbide over unequal pay. Do you consider these women heroes?
Oh, unquestionably. I've said, and I'll keep saying, that they should be as famous as Anita Hill. The kinds of things that they did when the law was as undeveloped as it was, for them to have stepped forward and stuck with it, especially when their financial means, and for the most part, were so limited. And even Ann Hopkins became a single mother during this case and had 3 kids to raise while out of a job. They are absolutely heroes in my book, because I'm an attorney and I use these cases every single day, and we're still building the law. They had no law to build on. They were making it up from scratch.
Because basically what Title VII was going to do was really a blank page at that time. You didn't know what it was going to do. You write that the law transformed, Title VII transformed what it means to be a woman in this country.
And it's because of those three areas of growth that I mentioned. Women, when Title VII was enacted, except for lower income women, disproportionately black women who had to work while have children, there was a conception of womanhood in this country that was very much mother first and employee second, if at all. There was a conception that her body was there to be ogled and consumed by the men in the workplace because that just made it more fun. There was the idea that only certain kind of jobs, clean jobs, dainty jobs, ladylike jobs were meant for women. And it's because of this one law that you see women firefighters, women cops, women construction workers, women CEOs, in addition to the jobs that are traditionally feminine, which are equally heroic. But the idea that women aren't confined by their very womanhood to be only one kind of worker.
So we've got about a minute left. What are the emerging issues under Title VII these days?
I think the biggest cases, and the one I predict will go to the Supreme Court, is around the area of LGBT discrimination. Not expressly included in sex, but courts, including the EEOC, have taken a lead on saying, because of Price Waterhouse, for instance, the idea of a sex stereotype and how a man is supposed to act and a woman is supposed to act shouldn't support discrimination against those groups. And I think the issue of pregnancy and motherhood remains the number one barrier to women getting ahead at work.
Why?
Because there's still so much bias and discrimination. We now have an architecture for challenging it because of these cases, but there have been documented studies that maternal wall bias is alive and well. Men are rewarded for becoming fathers, and women are penalized in every way.
And you mentioned the transgenders. That's a big issue. Also, things, religious observances, making, Muslims being able to pray, 5 times a day, or a Sikh being able to wear a turban, and black women being able to wear cornrows.
Yep.
Which all says that the good and the bad side is that you're going to be working. You're not going to be out of work anytime soon.
I'm sorry to say that that's true. Yes.
Okay. Fascinating book, and the history that it gives of what happened, especially in this particular area of women and work. I remember a classmate of mine from law school was talking about how her husband she had been a public school teacher, and her husband really was not happy about her going to law school. And he was talking about, it's just not that's a tough field for women. And she said, well, it's much more dangerous going to teach in the Bronx, than what I'm doing now. But it's the way people perceive of what women should be doing.
That's right. That's right. The Supreme Court had a case upholding a law that prohibited women in Illinois from becoming lawyers. And it was precisely on that logic that that it will diminish the home front relationship if women are out earning equal wages and having equal status to their husbands.
Well, we're out of time. I want to thank Gillian Thomas for joining me. Because of Sex, One Law, 10 Cases, and 50 Years That Changed America's Lives at Work has just been published by St. Martin's Press. For the City University of New York and 1 to 1, I'm Sheryl McCarthy. If there are any people you'd like to hear from or topics you'd like us to explore, please let us know. You can write to me at CUNY TV, 365 Fifth Avenue, New York, New York, 10016, or you can go to the website at cuny.tv and click on Contact Us. I look forward to hearing from you.